Welcome to the latest Evershed Sutherland Legal Insights podcast.
Hi everyone, welcome to our December Labour Exchange podcast with me, Clare Ward.
And me, Stephen Chegwin. So the main thing we're going to talk about is Christmas, yeah?
No, I wish. Been banging on about the Employment Rights Bill since it was laid before Parliament on the 10th of October, and particularly in our area, the impact of those proposals on the IR landscape. But there's so much to all of that. I don't think there's any way we can do it justice in one short podcast, especially because there's been three important cases that we also want to talk about. So I was thinking.
I think I know what you're going to say. Let's do things differently. Let's do things differently. Hey, so let's keep the listeners listening to hear the case summaries and some key takeaways on that. But what should we do next, Claire?
Yeah, then we'll do I reckon we do like a little mini series over the coming weeks where we'll cover the new rights of access, why recognition is going to be easier for unions to secure, all of the changes around industrial action, and then the new individual rights and obligations. And I think that if we chop them up, we can do 4 other little podcasts that people can listen to at their leisure.
Well, we don't want to bore people, do we?
No.
By getting them listening to us for a full 3 hours or whatever. So Claire, people keep talking about this Tesco case. Yeah, what's it all about?
So this was Tesco stores and Usdaw. And this is all about a dismissal and re-engagement process. So dismissal and re-engagement as an exercise to change contracts is something that has been around for a long, long time, but it's something that the unions have really successfully recoined as this fire and rehire, which people might be more familiar now with. So as it stands today, as long as a fair and reasonable process is followed, and an employer has a good business case, it's perfectly lawful to seek to change contractual arrangements by serving notice on one contract and offering an employee new terms under a new contract. And that's what Tesco were proposing to do. And in rather a novel case, the Usdaw trade union pursued an injunction to stop Tesco moving forward with that process, and the High Court granted that injunction, which was rather a surprise to us employment lawyers. And most recently, the Supreme Court has upheld that decision to grant that injunction, therefore preventing Tesco proceeding with these fire and rehire proposals. So in terms of what it's all about, Tesco wanted to remove a payment that had been given to incentivise employees to move to a new work location. And crucially, the issue was that in the negotiations with Usdaw, they had agreed that this would be a permanent contractual entitlement. And the court found that that meant that it wasn't then open to Tesco to try and remove that permanent payment by taking this dismissal and re-engagement process. So really the takeaway from this case is being careful about what promises are made in negotiations. Sometimes employers get negotiation fatigue and at the very end make statements and enter into agreements that actually later can tie them up in knots. And that's what happened here. So if people want any more detail, we have got a briefing that's available on our website. And there's also our tracker on there that gives some more information on the government's proposals to reform fire and rehire. So, Stephen, the RMT and Nexus case is a pretty technical case, but again has some important takeaways. Can you break it down?
Yeah, sure. I like my techie ones. Okay, so this case then, RMT and Unite and Tyne, and we're passenger transport executive trading as Nexus. This case is really about mistakes which have been made in collective agreements. So those agreements that employers make with trade unions, which normally, but not always, contain terms and conditions which affect the employment of employees. So in this particular case, the employees of Nexus brought claims against Nexus for deductions from wages based upon their understanding of this collective agreement that was made between Nexus and the unions. And the employees won their case, and they successfully argued that the agreement said what they thought it said, and therefore they all won deduction from wages complaints and won some back pay. So in response to that, Nexus then launched some legal action against the unions, so RMT and Unite here, arguing that there was a mistake in the collective agreement. So it didn't reflect what the intentions were of both the employer and the unions when it was drafted. And what they were asking the court to do is add additional words into the agreement to rectify that mistake. So for those geeky like me, this is a claim for rectification. And what the Supreme Court said was that, well, if there is a claim of rectification, then that should have been brought against the individual employees rather than the union itself. And that's mainly because an agreement between a union and an employer is not normally legally binding, but it is as between the employer and the employees. So therefore, the action failed on the basis that the Supreme Court said the union wasn't the right defendant to that claim. And in dismissing the claim, the Supreme Court also dismissed Nexus concerns about bringing proceedings against individual employees. And what Nexus was saying was, well, that would clearly have undesirable consequences if claims were brought against the employees, which would include damaging industrial relations with the unions and with the employees themselves. And what the court said was, well, that mistake could have been raised in the defence against the unlawful deduction from wages claims in the employment tribunals. And had that mistake been raised at that point, the employment tribunals could have treated the agreement as rectified. So effectively, the employment tribunal could have rectified the agreement at that point, and then when they could have then went on to dismiss the unlawful deduction from wages claims. So I suppose the takeaway from all of this is that if there is a mistake in a collective agreement, so it doesn't represent what the parties intended, it should be raised as a defence against any claims that the employees bring in the employment tribunals or indeed in the county court, if that's where it's raised. So quite a techie case. I know we've got a bit of another techie case which you're going to cover now, Claire. So do you want to talk to us about the withdrawal of check-off, because that's come back around, hasn't it, in one of the more senior courts?
It has, yeah. So this is another Supreme Court case, and this is all about unions enforcing check-off arrangements. So check-off, of course, is where employees authorise their employer to deduct their union subscriptions from their wages and then pay that money over to the union for them. And in this case, 3 government departments had just unilaterally withdrawn those arrangements, and the employees successfully complained that withdrawing that facility amounted to a breach of contract. So they had a contractual right for those check-off arrangements to be in place. Now, so they were successful in their claim, but this case actually involves PCS's involvement, because withdrawing the check-off led to a substantial reduction in PCS's subscription income, presumably because those individuals may not have then gone on and signed up to pay by direct debit. But PCS were not a party to that check-off agreement. They weren't part of that contract, which was between the employer and the employee. So they weren't able to sue for breach of contract in the same way that the employees were. But again, in a sort of a novel use of the law, they brought their own claim, relying on a little known piece of law which provides for third parties to enforce terms in a contract. And the Supreme Court has upheld their claim, in particular because the employees' contracts of employment didn't include anything that indicated that there was a common intention of the parties that those check-off arrangements couldn't be enforced by PCS, and PCS will essentially be awarded damages. So in terms of the takeaway, employers really ought to be thinking about the way in which the check-off arrangements are described, both in their contracts and their collective agreements, so that they have that discretion to withdraw them if they want to in the future, and also if they are thinking about withdrawing arrangements, that they think carefully about if and how that they should go about that. So we've given you a little bit of a whistle-stop tour through 3 quite technical cases, and they've been the key developments over the last few months in the labour and trade union space. Of course, the big news, if you like, and the things that are kind of dominating the press, if you like, in this area really is around the Employment Rights Bill and the forthcoming changes, particularly in the trade union and labour relations space. And so Stephen and I will be back with a little mini series of podcasts to talk you through those changes.
So we'll see you next time.
See you next time. Thanks,
Bye.
everyone.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.